Kesikian lu sawa. Mina ako manina nito na minsa una ndo ni na ako manana engineer.
I need to see the accused. Please just relate yourself. I can't confirm. Okay, let's try again.
Sonko, Peter Karaoke, Patrick Mogangi, Wambua Daga, Andrew Nasego, Samuel Mwangi Dungu, Edwin Karaoke Murimi, Lawrence Mwangi Mukuro.
At the enterprise. And your name? Yeah? Anthony Moura appears as
Anthony Moura Nanga.
is appear. Yeah? Fourth. Fourth. 12. So present represented by 12. Yes.
Ross Jerry, Asbab Auto Limited, ROT Security Limited, High Energy Petroleum Limited, Frederick Odiamo alias Fred Oyugi, Web Drive Limited, Web Drive Limited, Yango Tomo,
Murkomen. That name is long. Let me write it.
Sorry.
Kipchumba
Senator Murkomen.
Murkomen. Yes.
Honorable Senator Mutula Kinoti.
And I do appear together with my learned friend, Mr. Mungai,
Okay.
for the third accused person.
Mr.
Mungai. I do appear with Mr. Mungai for the third accused person in case number 32.
Yes. Okay. Next. Yes. Yes. Guilty were entered respectively. It was at that stage that the prosecution indicated that they were only opposed to the release of accused one in both ACC 31 and 32 of 2019 on bail. They were not opposed to the release of the rest of the accused persons on bond, but requested the court to consider imposing some conditions which they laid bare before the court. On the same date, I dealt with issues such as those of health of accused, and hence I will not consider the same in this ruling. The parties were allowed to canvass their respective positions on the matter of admission to bail for accused one. They relied on several authorities to assist or persuade the court in either admitting accused one to bail terms or not. As much as I may not cite each case, I will only rely on the relevant pronunciations made in the respective cases in order to arrive at a conclusion and make a finding thereon. In opposition to bail in respect of accused one, the prosecution relied on the affidavit of Simon Chepka, a forensic investigator with the Ethics and Anti-Corruption Commission here in after EACC. The affidavit was sworn and filed on the 9th of December 2019. Among the grounds put forth by the prosecution were that if accused one is released on bail, there was a high likelihood that he will interfere with witnesses who are his junior employees, as he is the chief executive officer of the Nairobi City County, and that he had used his position to threaten the county executive committee members from recording their statements at the EACC. Hence, releasing him would interfere with investigations. That on 6th of September 2019, he attempted to escape from lawful custody. On 12th March 1998, he was convicted in criminal case number 1727 of 1996 and criminal case number 675 of 1997, and sentenced to Kenya shillings 500,000 and 200,000 respectively, in default to serve 6 months in jail for each count. Sentences to run consecutively. This was because of failure to appear in court. He was then committed to jail at Shimola Tewa, where he sought for treatment at the Coast General Provincial Hospital, where he escaped from lawful custody. That accused one still has a pending criminal case number 275 of 2011, where he was granted anticipatory bail, via Mombasa criminal application number 244 of 2001, but declined to present himself before court. A warrant of arrest was issued by the CM's Court Mombasa in criminal case number 275 of 2001. That the offenses facing accused are grave and serious, and it will be in the public interest to deny bail. It was also submitted by prosecution that the signal submitted by accused 1 to court referred to case number 80 of 2001, where A1 sought revision for the reduction of sentence of 6 months for the consecutive sentences in criminal case numbers 1727 of 1996 and 675 of 1997. And it was after case number 675 that the accused absconded. That what was called a signal did not anywhere talk about success of an appeal and reduction of sentence. Further, that the prosecution had not been shown the alleged proceedings in criminal case number 8635 of 2000, and that a certificate of good conduct was not evidence of court proceedings. That EACC forms for clearance were self-declaratory. The prosecution further argued that circumstances of accused 1 were different from those of other accused, that there was no discrimination against accused 1 as alleged. Mr. Miller for accused 1, who teamed up with several other counsel, raised objections to the application by the prosecution on denial of bail in respect of accused 1. They argued that there were no annexures or any factual basis on the allegations laid against accused 1 by the affidavit of Simon Chepka of the EACC. This was the general argument on all fronts, including that of interference with witnesses, that CEC members were summoned by the EACC and had recorded their statements on 15th November 2019, whereas accused 1 recorded his on 30th August 2019 at 10 a.m. That accused 1 was alive to lay down procedures and had decided to follow the law in order to address his grievances against senior EACC officers by filing constitutional petition number 34 of 2019, which is still pending in the High Court. On the issue of fleeing out of jurisdiction, it was argued on behalf of accused 1 that he was arrested within 2 hours of the DPP's arrest order, and that he had not been notified, and a question was posed as to how one would run away using a public highway. The accused was unfairly treated during his arrest and was assaulted. Further, accused 1 was cleared to run for a parliamentary seat and was member of parliament for Makadara when criminal case number 8635 of 2000 was going on in Kibera. The defense produced a signal in respect of an appeal number 80 of 2001 by Ogu J, who is now late, which they argued had not been appealed against, that no warrants of arrest had been attached, that there were chances to arrest accused 1, one being his visit to Shimolatewa in 2011, and they questioned why he was not arrested then. That accused 1 was not a dangerous person. He had been cleared to run for parliamentary seat as an MP for the Senate and for governor of Nairobi. They presented a police clearance certificate, otherwise known as certificate of good conduct, that he was also cleared by the EACC, which documents they cannot renege from. Further, accused 1 was honored with the honor of Elder of Burning Spear, EBS, and was also a member of the International Police Association. They handed over a respective identification and a badge to the court, and that he was also a holder of an award of the Good Deeds Ambassador by the UN. It was also argued that disputes as to tenders allowed office holders to continue holding office till their culpability was decided by a court after a trial. That there being no substantive holder of the deputy governor's office in Nairobi, charging of accused 1 was to buy him from office, and this court was requested to balance public interest on how people of Nairobi will be served. With all due respect to counsel on this aspect, the issue of lack of a substantive governor of the County of Nairobi has been a subject in the public domain, which I take judicial notice of due to its notoriety. However, be that as it may, this court has not been clothed with the necessary jurisdiction to give it the necessary authority to even touch on the said subject raised in submissions, and I leave that issue at that. The court was also referred to the cases of Professor Swazuri in Criminal Revision number 13 of 2018, that of Amritral Jivraj Shah versus Republic in Miscellaneous Criminal Application number 35 of 1984, Republic versus Cyrus Mwangangi Kimumu 2016 EKLR. They also complained that all exhibits tendered were copies and illegible. The court was urged to rely on Article 180 and 181 of the Constitution and several other cases, and that it should be found that the DPP misused its constitutional powers and discriminated against the accused. Further, that the court had also, at more or less, settled terms of bail, and several figures were floated to the court to consider. If a company was accused, the court was urged not to impose punitive terms, as the representatives of the company were also accused within the same charges. Some counsel acceded to any conditions to be given out by the court, but urged reasonability due to the presumption of innocence. Some accused were said not to be having passports. I have considered all arguments by all parties that made presentations before me. First, I will address the documents placed before me in order to answer the question as to whether or not A1 should be admitted to bail. On the affidavit of the prosecution, I said this: an affidavit is a source of evidence. It lays bare before a court of law what the deponent wants the court to believe and rely on. Evidence means something including testimony, documents, and tangible objects that tends to prove or disprove the existence of an alleged fact. Anything presented to the senses and offered to prove the existence or non-existence of a fact. In order to rely on such evidence, it has to be very clear. Annexures SPC 2, SPC 6, SPC 9 were not legible. The court could not discern what kind of evidence was being relied on by the prosecution. The prosecution is advised that any such evidence must meet the threshold of good and best and of the good and best evidence rule. In arriving at a proper conclusion and decision, there are several tools available to this court to use. The tools available, among others, include the laws, policy, pronouncements of the court. On law, the Constitution of Kenya at Article 49(1)H provides that, I quote, an accused person has the right to be released on bond or bail on reasonable conditions, pending a charge or trial, unless there are compelling reasons not to be released. Article 49(1)H is operationalized by Section 123A of the CPC Cap 75 laws of Kenya, which requires the court to have regard to all the prevailing circumstances, and in particular, the nature and seriousness of the offense, the character, antecedents, associations, and community ties, the defendant's record in respect of fulfillment of obligations under previous grants of bail, and the strength of his having committed the offense. Also, whether having been previously granted bail, failed to surrender to custody, and if released on bail, whether or not subject to conditions, it is likely that he would fail to surrender to custody. All the above grounds were argued by the prosecution and responded to by the defense in relation to accused one. There is also guidance given under policy and guidelines. On the nature of charges, it's assumed that where the charges are serious and punishment heavy, there are more probabilities and incentives for the accused to abscond. Where there is a strong prosecution case, it may be justified to subject an accused person to pre-trial detention, sorry, where evidence against the accused is strong. Let me read that. Where there is a strong prosecution case, it may be justifiable to subject an accused to pre-trial detention where evidence against the accused is strong. However, this is available where all prosecution witnesses have testified. On the likelihood of interference with witnesses, bond will only be denied if there is strong evidence of the likelihood of interference with witnesses which is not rebuttable, and the court is not able to impose conditions to the bail or bond to prevent such interference. On the issue of flight risk, it must be demonstrated that the accused has no permanent abode and may therefore fail to attend court if granted bail or bond. This is especially applicable to foreigners whose host countries do not have extradition treaties with Kenya. There is also the aspect argued of leading supporters to the EACC who cause destruction. Pre-trial detention may be necessary to preserve public order, where it is demonstrated that the public response is such that if the accused is released, it's likely to lead to public disturbance. Besides policy guidelines, the court is guided by pronouncements of superior courts whose pronouncements on matters of bail and bond are binding on this court due to the nature of their binding, due to the principle of their binding nature and respect for hierarchy of courts. Several authorities were cited. Be that as it may, this court is aware that some of its findings on bail bond, especially on requirements on cash bail to be deposited in court and security of bond terms, has been interfered with downwards, and there seems to be some kind of uniformity which the court will apply when it arrives at that stage. It was argued that the circumstances facing A1 would be the same as the decision in revision number 13 of 2018, that is Professor Mohammed Swazuri and 6 others versus the Republic, among others, and that most authorities cited by the prosecution were in respect of murder and robbery with violence. The most recent cases that are related to this matter are that of Moses Kasaine Lenol Kulal versus DPP 2019 EKLR Nairobi, and Ferdinand Ndungu Waititu Babayao and 12 others versus Republic 2019 EKLR Nairobi. At paragraph 60 of the Lenol Kulal case, Mumbi Ngugi J found as follows, and I quote, I accordingly decline to exercise powers of revision over the decision of the trial court in this matter. The term set for the applicant's access to his office shall remain in force for the duration of his trial. I need not add that it is in the public interest and the interest of the applicant that the case against the applicant in ACC number 3 of 2019 is proceeded with expeditiously. W. Ngenye Masharia J. in the Waititu case, after considering the application before her, in the premises, I find no irregularities, impropriety, illegality, or incorrectness in the order of the learned trial magistrate in directing the first applicant not to set foot in the offices of the county government of Kiambu whilst the trial is ongoing, save for the window accorded by this court to go and collect his personal belongings. You can see paragraph 52 of that particular authority. In the same authority at paragraph 8, the same judge also found as follows, and I quote, having warned myself, bearing in mind the presumption of innocence, I find in regards to the first applicant, the amount of Kenya shillings 15 million cash bail or bond of 30 million with a surety of similar amount is appropriate, more so in view of my observation regarding the reasons the conditions to grant the bail were attached. In arriving at appropriate bail terms, I have considered all the charges, and in particular the charges facing each accused person, the roles played by each accused as alleged in the charges, the nature of the offenses, and the amounts involved. More so, I have taken into consideration that the purpose of bail bond principally is to give such terms in order to secure the attendance of court wherever accused is required. I have also considered the aspect that denial of bail should be the last resort. Before I consider whether or not to grant bail terms to accused one, there is one aspect of the trial raised by Mr. Nyamodi that must be addressed. That is the aspect of disclosure. There were presentations by learned counsel on this issue, especially on the requirement of disclosure count by count. The court was informed from the bar that the High Court in ACEC Criminal Revision number 42 of 2019 stated the requirement and that there is a constitutional application within the application for review to the Chief Justice to empanel a bench of 3 judges to hear the constitutional application. My order has not been set aside. In the case law of Society of Kenya versus AG and Central Organization of Trade Unions, the Supreme Court in petition number 4 of 2019 at paragraph 91 gave directions on what a judicial officer should do on learning of an appeal preferred on the same subject matter before it. I'm aware that the above mentioned revision is pending before the High Court, and I take judicial notice of it. The determination therein may as well have a bearing on the requirement of disclosure count by count, which this court has interest in. The court is proceeding on leave within a week. The said information, the information is that the matter is coming up before the Honorable Judge on 17th of December 2019. In fixing this matter for the next court proceedings, I will consider the above situation. In attempt to rebut evidence by the prosecution, accused one produced a signal, a certificate of good conduct, identification showing him as a member of the International Police Association, and also informed the court that he had been honored with the award of the Elder of the Burning Spear, and that accused one was an holder of an award of Good Deeds Ambassador by the UN. The respective agencies that either gave him the clearance certificate or the awards know better the reasons why they gave him the clearance certificates or honored him with the awards. Since no such evidence was placed before the court was denied an opportunity to make a finding on the same, as courts only give pronouncements based on evidence. After having considered all the material placed before me, I am of the considered opinion that all accused are hereby admitted to bail terms. These bail terms must be adhered to the letter. Any violation shall lead to cancellation of the bail terms. In terms of companies charged, I have considered that they are legal persons who cannot be sent to jail. Hence, the bail terms will be a consolidation to be made by their legal representative. To be very clear, the bond terms on the legal representative alone will suffice for the limited liability companies. Now, the accused are admitted to the following bond terms. Accused one to a bond of 30 million with one surety of similar amount and a cash bail of Kenya shillings 15 million. Accused 2, 3, 4, 5, 6, 7, 8, and 9 to a bond of Kenya shillings 3 million with one surety of similar amount, or to a cash bail of Kenya shillings 3 million. For accused 10, 11, 12, 13, 14, 15, 16, and 17 to a bond of Kenya shillings 30 million with one surety of similar amount, or a cash bail of Kenya shillings 10 million. The accused who have not taken plea will only have their bonds processed after plea. All parties in the case, including but not limited to the office of the DPP, the EACC, the accused, are hereby prohibited from commenting on this case on social media in whatsoever manner, and that should be taken seriously. The court, by virtue of the above pronouncements on Ngugi J and Ngenye J, directed that accused be barred from office. If need be, he can be escorted. The court, by virtue of the pronouncements of Ngugi J and Ngenye J, directs that accused one be barred from office. If need be, he can be escorted to his office by the IO in this case, or any other authorized officer to enable him access and pick his belongings. This will also apply to other county employees charged. Accused one is hereby required to ensure that his supporters do not cause disruption to any non-legal process or disrupt peace in whatever form. All accused to deposit their passports and all traveling documents in court. In any case, the Director of Immigration is directed to ensure that none of the accused leaves the jurisdiction of this court without the permission of the court. For this purpose only, the order herein shall be extracted and served on the Director of Immigration. All accused are barred by themselves or by proxy from communicating or approaching any witness in this case in whatever manner. The orders herein apply mutatis mutandis to ACC case number 31 of 2019. That is the ruling of the court. Excuse. Yes, Mr. Mayor.
Yes, Your Honor, the County Commission would like to apply for type rulings in the proceedings.
Yes?
To apply for type ruling.
Yes.
Your Honor, secondly, as far as first accused is concerned,
Yes.
we would also like to inform the court that we were served this morning with a letter from the Kenya Prison Service that was indicating that the accused person, number one,
Yes.
is currently admitted at Kenyatta National Hospital for treatment.
But I can see him here.
Yes, Your Honor, I'm coming to that. I'm coming to that. I'm coming to that. And so, yes, and they have attached what they call a production notice of order for disciplinary action. Now, most importantly, Your Honor, is when we last appeared before you, we gave directions that the first accused person is seen by both his personal physician and a physician from the prison authorities. And Your Honor, that was done. And on the night of 9 December, or the evening of 9 December, the first accused was seen by both physicians at Kamiti Maximum Prison. And they confirmed that his position, his medical position, was not safe for him to remain in the prison, and they immediately admitted him to Kenyatta National Hospital. Your Honor, the first accused have been receiving treatment at Kenyatta National Hospital. And Your Honor, as you can see from the attached letter before this court now, by 3 medical practitioners. One being his personal doctor, the other one being the doctor from Kenyatta National Hospital, and the third one being a doctor from Kenya Prisons Authority.
Yes.
If you look at that letter, paragraph 1, it says that he was admitted on the 9th of December at Kenyatta National Hospital.
Yes.
It proceeds to say he also had a painful left-sided swelling on his chest, but there was no prior history of hypertension. Now, Your Honor, if we go to paragraph 2, it says, on examination, it is an fair general condition, no pallor, no jaundice, no edema. BP on arrival was at 183/134, and the repeat was at 189/120. Now, it goes on to say that local examination revealed a tender swelling on the left side of his chest, and proceeds on to say various investigations were done, and the findings were as follows. ECG was essentially normal, chest showed no fractures, abdomen and bilaterally degenerative changes. And it goes on to say, the last paragraph, the governor Mike Sonko is being managed for uncontrolled hypertension, soft tissue injury, and bilateral hip osteoarthritis. Is being managed on antihypertensives and analgesics. The BP is settling down, but other investigations are still ongoing. He awaits further cardiac evaluation. Your Honor, the purpose of this letter also show the report is to show that actually he's actually supposed to be in hospital. And the earlier prison's letter also indicates the same. However, Your Honor,
Just a second.
for himself and the other accused persons. So he's actually here contrary to doctor's instructions. And if you notice, he also has on his hands the straps that show he was actually on a drip. And he was actually brought here in an ambulance from what now?
Yes.
He was brought here he was brought to court in an ambulance. Your Honor, our humble application therefore is that this court directs that he proceeds back to hospital as we process the terms of bail. The court should take notice of the fact that he's actually here simply because he insisted, contrary to the instructions of the court. We therefore pray that
although the doctors refused that he should not come in. If you look at him, I'm sure you are you're in a advantage position to look at him. He has equipment in his hand for intravenous infusion, otherwise known as for drips. Your Honor, he came here by an ambulance, and Your Honor, although you've given an order barring him from office, it does not extinguish the very important fact, Your Honor, that the health of an elected governor is very important. In fact, when you gave your order on 9th, Your Honor, just that part, just requesting that. Yes, Your Honor. Because Your Honor,
He's on his feet. Which chances? I'm driving somewhere. Which chances?
those in charge.
So you feared that you would run away?
No, we fear not only that we can advance in the circumstance. And so we took a risk and it is so long and arrived here just before we continue to make the decision. And this application we're making is
Mr. Murkomen, you know I'm smiling. I know you don't practice in our courts. These are not that each individual right of an accused is considered singular, even if they are charged together. Yeah? Which means absence of an accused person cannot charge the rights of other accused persons. So, your fear was unfounded. I can tell you from where I sit. So you didn't have to disturb a sick person in the hospital. I still would have gone ahead and given direction. I believe get hold of that authority, it can get you in future. That's by the extent of the I'll explain to you the court's position. You will have to yes.
I'm wondering whether it's a mistake, so that if it's a mistake, then we can rectify and we bring it also that they are placed on the same capacity. I thought that the cash bill would be lower than before. But if it's because even for the past accused, you're granted the whole higher.
Should not unduly be applied to frustrate the functionality of the business. My name is Mugaka. Watching
To move in the direction that we want to move. Clearly. But I thought these matters were consolidated and were had as one. Mr. Kidd.
That's an issue of that.
I'm the one who will send the release. So don't worry. Unless you don't want me to sign your application. Because I understand my conditions better. Yes?
The prosecution proposed that application for the following reasons. One, Your Honor, you have been given a letter dated today by the officer in charge of committing maximum prison, indicating that the first accused is unable to appear in court today due to his medical condition. Your Honor, the same officer, I think that letter has been given to the court. The same officer, Charles Mtembei, the officer in charge of committing maximum security prison, has authored a letter of even date, that is the same date today, stating that the first accused has been discharged to attend court today. Those two letters are before court. Secondly, Your Honor, heavy reliance has been given to the medical report by Dr. Esther Wafula, an undated medical report indicating that the first accused needs further medical evaluation. However, this is not the doctor who was attending to him at Kenyatta National Hospital. However, Your Honor, I wish to refer you to a letter dated today also by the Director of Prison Health Services, where the said doctor has analyzed the medical condition of the first accused and recommended that the first accused continue with treatment at Committee Maximum Prison Health Facility. Therefore, Your Honor, until and unless he satisfies the bond terms, if he is to be remanded, we pray that he be remanded at Committee Maximum Security Prison. That is all.
So you'd rather your client be given the best treatment, be seen by the government physician, position and is on for purposes of reference to hospital. And that is the best way it's done, because I think there's the issue of security. You can see how we are marooned. Yeah, and you had, though I didn't get there to the submission, you had the submissions from none other than the state. So those conditions, those situations have to be taken care of. Because you cannot assume that we don't live in this planet. So the best order is to enable your client to go to hospital from where he sits.
Just one thing, Your Honor, the concern that we had was the move, truth be told. They have already charged you, Your Honor?
Now, Mr. Kinyanjui and all the other councils,
Yes.
I think next time I will delve into the issue of a lead council where you are more than one.
Much of that.
Yeah, because you spend so much time arguing on a simple issue instead of giving Mr. Miller instruction. And I think next time I will rule on that. Though I need not rule, it's an establishment. For heaven's sake, you are 15. Yesterday, the other day you were 12. Now you are 15. So the issue of lead council comes in. Yes. So let me just...
Senators who are here. Your Honor, my point is, in this court now, we are three independent arms. So, to save court time, I'm just giving an indication that when the matter comes up next, we shall make a formal application that Senator Rosa Jr. and Senator Mokomen should not be given audience. Because, Your Honor, that would be breach of trust. Your Honor, they are here with security accorded to them on behalf of the taxpayer. Number two, Your Honor, they are also here representing a serious matter that is before you. The governor has been charged in relation to misappropriation of public funds from the same county in which they offer oversight role on it. So, Your Honor, my point is that I do not want to belabor this particular issue. Is that as a prosecution, we are taking this particular matter seriously. Yes, that's what I was telling you. We shall file a formal application. Yes, before this. And also the High Court. I'll do a petition. I'll just say, I'll file a petition.
Your Honor, we don't receive the willing decision, so really, it's superfluous.
On the health of accused one, I direct that either accused one processes bail terms and is released immediately, or in the likely event that it does not succeed, his doctor in consultation with the doctor prison services make an immediate recommendation for admission outside committee maximum prison. So mention of this matter is on 15th of January. For those I've dealt with, please walk out pole. Let me listen to the other counsel. Or alternatively, we adjourn for about 10 minutes.
Yes.
Simplikia daerah dulu.
Even the gentleman is my friend. Yes, we went.
Nuke.
Ni nuke de we.
We got this in the
Mama school, man.